Now, activists are describing the latest ruling of the Supreme Court, which now allow dual citizens to hold certain public offices as bold decision and a victory for democracy. The APS Court, in a 6-1 majority decision, struck out provisions of the Citizenship Act as unconstitutional, paving the way for dual citizens to enter certain hitherto restricted public offices. Koko Asante is here with me in the studio as we look at the decision taken by the Supreme Court and which or what office is affected with this latest decision. Koko, tell us more about this decision of the court.
Well, so a lawyer, Bright Ochre Ejekum, filed this action in the Supreme Court, challenging sections of the Citizenship Act passed in 2000, which prohibited certain persons from having access to certain offices. According to Bright Ochre Ejekum, those specific acts in this section that I'm talking about clearly contravened the Constitution of the Republic, for which reason they wanted the Supreme Court to strike it down as unconstitutional. It took some time, some battle back and forth in the Supreme Court. Bright Ochre Ejekum, being a lawyer, and his team of lawyers made their point for why they believe that this section of the Citizenship Act was unconstitutional and have to be struck out. The Supreme Court, after thorough looking at the decision, now have rendered their decision, and as of yesterday, by a 6-1 majority decision, the court has ruled that section 16.2a and 16.2a to L of the Citizenship Act 2000 is unconstitutional, and same is struck out as unconstitutional.
Now, let's get into the specifics of it and the public office that are affected by this, decision by the Supreme Court.
So, Elton, as of yesterday morning, if you were a dual citizen, you could not be the Chief Justice of the Republic. You could not become the Commissioner of the GRA or the Value Added Tax Service. You could not become the Director General of the Prison Service or the Chief Fire Officer or even a Chief Director of a ministry or be in the military at the rank of a colonel as of yesterday morning. But since then, the Supreme Court has struck out these sections of the Citizenship Act that allows these persons now to take these offices. So again, the Chief Justice can now be a dual citizen, the Commissioner of the Value Added Tax Service, the Director General of the Prison Service, the Chief Fire Officer, Chief Director of a ministry, or someone in the military at the rank of a colonel or any other security service. These persons, per this new Supreme Court judgment, 6-1, can now hold public office, these public offices, even if they are dual citizens. That is, if they are Ghanaians and then hold the passport of another country.
So if I'm a Ghanaian, if I'm also a citizen of the United States of America, now I can hold the position of Chief Justice.
Yes.
I can hold the position of head of the prison service.
Yes.
I can be in the military to the level of a colonel, but not beyond colonel.
Beyond colonel. Because in fact, if you look at the Citizenship Act, it talks about persons who cannot become the Chief of Defense Staff, and those are dual citizens. That one, the court did not touch that. The Inspector General of Police, for instance, the court did not touch.
I'm surprised because head of the prison service is almost equal
at the rank of the IGP.
At the rank of the IGP.
Exactly.
So the head of Ghana's prison service can claim allegiance to another country. And the Supreme Court finds nothing wrong with it.
Nothing wrong with
and
it.
so is the Chief Justice of the Republic.
The Republic. And in fact, that is why some people have raised certain concerns about it, that these are very high offices. The Chief Justice and Justices of the Supreme Court, that is the apex of the judiciary. And if these persons can go on to become dual citizens and still hold their offices, but if you are, for instance, the IGP, you cannot do so. So there is a seeming contradiction that people have raised it, and you make the point about the Chief Fire Officer, that is the head of the fire service, the Prison Service Director General. These are analogous to the IGP, for instance, or the Chief of Defense Staff. The court says in this analysis that those persons cannot become dual citizens, or if they are dual citizens, they cannot go ahead to become to serve as Chief Justice. However, these persons that I've listed.
And this is a 6-1 decision, overwhelming, if you like.
Overwhelming decision by the Supreme Court.
The other angle to this story is why MPs or people who are aspiring to become President of the Republic will not have to renounce their citizenship with another country.
Yes.
MPs, there's somebody who is filed a private member's motion demanding a review of this provision. The Supreme Court decision doesn't touch members of Parliament.
Yes. In fact, the distinction is that when it comes to what bars members of Parliament from not being able to become dual citizens and serve in Parliament, that is the Constitution itself. So to be able to take that out, you have to look at the Constitution. The Supreme Court cannot declare acts of the Constitution as unconstitutional. So, because that is the constitution that has been written. They can interpret the constitution, all right? And if they interpret that to say that, well, MPs can do that, then that is fine. But as of now, they haven't done so yet. And so the members of parliament, if they have any hope of being dual citizens and staying in parliament, then they have to bank that hope on Kennedy Osei-Nyako's private members bill that is going through the mill in parliament. It's faced some delays. He says, with the judgment that has come in now, he expects that that will now move in speedily when parliament resumes from its Easter break. But that controversy will continue to go on, that members of parliament who make laws cannot be dual citizens. But the Chief Justice, who also make laws, by the way, if the Chief Justice was on this panel, what they have done yesterday was making law, interpreting, striking out certain sections of the Citizenship Act, and invariably making law. But these persons can't go ahead and be dual citizens, but MPs cannot be, at least for now.
Okay, thank you so much. Let's see if we can analyze this matter much further. And CDD fellow Professor Kwaku Asare joins us via Zoom. Prof, it's always a pleasure to have you. Good afternoon.
Good afternoon. Thank you for having me. I appreciate it.
I'm sure you are excited by this decision, but I'm wondering what went into the minds of our justices to come to such, unprecedented decision.
Well, that will be very interesting to find out. As at now, we don't know, because to the best of my knowledge and information, the opinion is not out yet.
Yes.
And so we cannot speculate as to what went through their minds, but we can accept the outcome and rejoice about the outcome, because for some of us, this is a battle that we have been waging since 2006, when they initially attempted to disqualify Mr. Akwasi Agyeman as Kufuor's nominee for the Ashanti Regional Minister. And then we had the Adamu Sankedi case, and then we have Mona Kwate, we had Charles Adubuahin, and then Jechi Kwesin. So I've always had problems with the way the court and the country interpreted Article 94(2)A and also Article 8(2). Now, let me be clear about what has happened.
Right.
Article 94(2)A has not been touched at all by the court by this decision. Article 94(2)A has not been touched at all. That is the article that disqualifies persons who owe allegiance to countries other than Ghana from becoming MP. And of course, if you cannot become MP, there are other positions that you cannot hold. For instance, you cannot be a minister, you cannot be
the president.
The Lands Commission, you cannot be on the Public Service Commission, you cannot be on the Electoral Commission. That has not been touched.
Right.
That is in Parliament right now. We are working very hard to try to amend that with Kennedy Osei-Nyakom, as you mentioned. Second, they have not touched at all Article 8(2). Article 8(2) deals with dual citizenship, and the positions excluded under that include ambassador or high commission, secretary to the cabinet, chief of defense staff, IGP, director of immigration service, and so on and so forth. What the Supreme Court has searched is Section 16(2) of the Citizenship Act. And this was basically a problem that I actually have gone to court with this same problem, Act 591. And I argued that it was unconstitutional for Parliament to add offices without specifically amending the Constitution. But the court then did not agree with me. It was a 7-2 decision. Justice Sophia Kufu and Justice Rose Owusu agreed with me, but 7 of the men disagreed with me. So I'm very happy that the court appears to have departed from Asare or overturned Asare and have now said that, look, you cannot just disqualify people without amending the Constitution. If you want to disqualify people, then you have to amend the Constitution. You cannot just get a majority of 1 and then say, well, everyone who works for Joy FM has been disqualified from holding office. No, you can't do that.
Right.
It has to be a constitutional amendment.
But Prof, let's look at the moral aspects of the decision taken by the Supreme Court and the concern for a lot of people, the worry that they've started anticipating that we're going to have our Chief Justice who may be holding allegiance to another country, a colonel in the Ghana Army, the head of the prison service now have liberty to own allegiance to another country. In terms of the argument on the street and the morality of it, is there any cause for worry? Or this is the new trend that we must all follow?
No, there's no cause for worry. These are all ancient arguments. You know, Ghanaians celebrate justices who go to serve in the Supreme Court of other countries. So, for instance, Justice Doche used to serve in the Supreme Court of Gambia. Justice Brobe, Justice Apalu, a whole host of Ghanaian Supreme Court justices go to serve in the Supreme Court of other countries. We celebrate them. When people sit on the Supreme Court to decide cases, I will be shocked if they are sitting there saying, well, I am a Ghanaian and I'm also a Nigerian, therefore I'm going to rule on the case differently. If there's a judge who thinks this way, then he has bigger problems than what people on the streets are worried about. Similarly, when you go to the United Kingdom, you don't even have to be a UK citizen to belong to Parliament. If you are a Ghanaian and you have residence in UK, then by virtue of being a Commonwealth citizen only, you are entitled to contest for a seat in the Parliament of UK. It hasn't bothered them. It hasn't ended the democracy in United Kingdom. Let's go to Nigeria. As far back as 2000, maybe earlier, the Nigerian Supreme Court said that anybody who is a Nigerian cannot be disqualified from seeking public office or elective political office. In other words, the right to vote is intimately related to the right to be voted for. And therefore, anyone who has the right to vote also has the right to put himself up for other people to vote for him. Nothing has happened to Nigeria, Sierra Leone, Botswana, South Africa. All these countries have dual citizens actively participating, and nothing has happened. In Ghana, there are people who are dual citizens who are intimately related to the decision-making process,
Right.
much more than single citizens. This has not ended the world. So we need to move into a different era where these archaic, obsolete, and vestigial concerns about other citizenships need to be consigned to the dustbin of history.
On the matter of the military, the court ended at the rank of a colonel. I mean, we are all waiting to read the decision of the court regarding this matter. But do you think that maybe they could have gone further? Because at the level of colonel, you are almost at a decision-making, position in the Ghana Armed Forces.
Yeah, I mean, previously, the law was that if you are a dual citizen, you could not hold the rank of a colonel. And the court has stricken that down, that you can hold the rank of a colonel. But let's be very serious for a change. I mean, why should we be concerned about a colonel who is a dual citizen, but not concerned about a lieutenant colonel who is, not a lieutenant colonel can be a dual citizen.
Exactly.
But somehow we become concerned if a colonel is a dual citizen.
Yes.
What is the big difference between colonel and lieutenant colonel such that we think it is okay for a lieutenant colonel to be a dual citizen, but he cannot be promoted to a colonel. I just don't even get the logic. I mean, is it that if you are a colonel, you suddenly have certain decision-making roles that can make you more susceptible to foreign manipulation? Then none of this happened. Let me tell you one other thing.
Right.
Throughout the history of the world, all the people who have subverted their countries, either in the role of a spy or in some other roles, were single citizens. There is no single instance anywhere in the world where a dual citizen betrayed his or her country. So again, I repeat, these are all, ancient thoughts, and but there is no evidence to back this fear, and we must outgrow the fear.
Right. Before I let you go, Prof, I mean, let's talk about the member of parliament angle to this. There's a private member's motion in parliament seeking to, get this matter resolved. Judge Kwesem is in and out of court virtually every day because he held a Canadian citizenship, and then, within a time frame allowed by the Electoral Commission, he was unable to do so. He's gone through a lot in view of this. Does this decision of the court solidify those who are pushing for reforms, especially when it comes to members of parliament, and how should the approach be?
No, absolutely. And let us be clear that there is a bipartisan support for the bill.
Yes.
That bill went to the Council of State, and the Council of State unanimously endorsed that. I know, as a matter of fact, that ex-President Mahama has said he supports that bill. I know, as a matter of fact, that President Akufo-Addo has said he will support that bill. I know, as a matter of fact, that my good friend, Vice President Bawumia, supports that bill. I know, as a matter of fact, that my good friend Afrafranto Alan supports this bill. I mean, everybody supports this bill because they have come, or we have all come to the realization that nothing will be lost if a member of parliament is a dual citizen, as I said, because nothing has happened in Nigeria, in Sierra Leone, in UK, in all these other places. If there is a dual citizen, he may be one or two or three people out of 275 in parliament. What is the fear that one, two, or three people who are dual citizens are going to go to parliament and suddenly cause havoc? Our bigger problem is not with dual citizens. Our bigger problem is with people, single citizen or dual citizen, who are greedy, who are corrupt, who are stealing money, and so on. To the extent that we allow ourselves to be diverted by these, ancillary matters, like what is your citizenship? What is your other citizenship? It just drives a wedge between single citizens and dual citizens so that they can't concentrate on what is keeping them hungry, what is keeping them jobless, and so on and so forth. We must now say, look, if you are Ghanaian, anywhere in the world, and you are good at what it is that you do,
right,
we welcome you to come and help us solve our problems. That is the mindset we use when we constitute the Black Stars. And that's why when Black Stars went to South Africa, they performed so well. Because we were not worried about whether Kevin Boateng, who is also a German, was going to take a penalty kick against the German national club.
Right.
Once you put on that Ghanaian jersey, then you are a professional. You set aside all these things about, well, I'm also no, you are a professional. And you're going to go and kick that ball. That is why the Serbian coach coached Ghana against Serbia. The fact that he was a Serbian did not take away from his ability to coach Ghana soccer team.
Right.
So I repeat, we are in modern times, and we must embrace the idea that because of mobility, people are going to have multiple citizenships. I want to end on one note.
Right.
President Nkrumah was a citizen of Ghana, was a citizen of Guinea, was a citizen of the United Kingdom. President Rawlings was a citizen of Ghana, and he was a citizen of the United Kingdom. In fact, until May 1957, all Ghanaians were UK citizens or subjects. The concept of Ghanaian citizenship is new. It only came into being on May 1, 1957. And when it came into being, we all became dual citizens because we were United Kingdom subjects before we became Ghanaian citizens.
Absolutely. Absolutely. Professor, thank you very much. And bottom line, we've been too protectionist. About time we loosen up and embrace change. Professor Koku Asare, a CDD fellow, and we've been looking at the Supreme Court decision that now allows the Chief Justice to hold dual citizenship and other, specified ranks in the public service. This